Hey guys, welcome to the Street Cop Podcast. I have with me, as always, Zach Miller. He is our case law expert. He is God's gift to law enforcement when it comes to the law. He is a instructor at Street Cop training. He's a blessing to all of us. He's got a lot of time on the job, and we're thankful to have him here. Our third time together in this podcast forum, giving you guys as much value as we can possibly give from the things we're collecting and the data we're collecting in the field of the common questions and trying to help give police officers in the United States some clarification on the law because there are a lot of misconceptions. So welcome back, Zachary Miller, third time in a row. If you're not watching this on Zoom, Zach shows up this week with his Street Cop training shirt on. Attaboy, Zach. I actually bought you a jacket to send to you, too. It just hasn't gotten here yet.
Can't wait.
Where do you want to start this week, Senor?
I guess probably Arizona versus Gant vehicle search incident to arrest. I think we covered the automobile exception pretty thoroughly over the last couple of weeks. So let's move on to search incident to arrest.
If you want Zach to answer a specific question, email zach@streetcop.com. It doesn't mean we're going to actually answer it, because if it's super obscure and it doesn't provide value at a generic overall level, maybe we'll take some time to answer it in the interim if we have a little downtime, but we're going to volley conversation back and forth. That's where your questions should be sent. But without further ado, let's go into Arizona v. Gant, the year, what it meant, what it said, and how we can apply it, and does it apply everywhere?
Arizona versus Gant, that was kind of a game changer. In 2009, it came out, and a lot of us were police officers before that. It really changed the way we do vehicle searches incident to arrest. Before Gant, it was wide open. New York versus Belton was the controlling case from 80, 81. It was when that came out. And pretty much if we arrested someone out of the vehicle, and it doesn't matter if it was the driver, an occupant, if we made a custodial arrest out of the vehicle, we got to search the entire passenger compartment of that vehicle as an incident to the arrest. We didn't have to have a particular justification other than the arrest. It's just like searching the person. We get to search the full person, all the pockets and carry belongings. We've got to search the vehicle. And of course, you can only imagine the amount of evidence that we would discover in contraband that really had nothing to do with why we were interacting with this person in the first place. So it was really a great windfall of evidence and contraband without any particular justification other than the arrest. And then along comes Gant. There was an arrest for the facts of the case very quickly. It's really straightforward. The officers in Arizona made an arrest, a custodial arrest for driving on a suspended license of Mr. Gant, which in Arizona, it was authorized. The custodial arrest was authorized. So it was a lawful arrest. And they searched him, and then they searched his vehicle, and I believe they found drugs in the vehicle. And ultimately, at trial, he argued that the search of the vehicle was unlawful because he's being arrested for driving on a suspended license, and there was no reason for the officers, he contended, to believe that they could find evidence of that offense, driving on a suspended license, in the vehicle. Nor did the officers have any reason to believe he had a weapon or was in any way dangerous to the officers. So the two traditional justifications for searches incident to arrest, the discovery of evidence and the prevention of its destruction, and the discovery of weapons or means of escape, those just they didn't appear to be present in this case. And he actually won that motion to suppress in the Arizona trial court and ultimately the Arizona Supreme Court. They agreed with his argument. Now that was inconsistent with Belton. The court in Arizona, in my opinion, didn't follow case law, the Supreme Court case law, and it was decided under the Fourth Amendment, not the Arizona Constitution. So the state of Arizona appealed it to the U.S. Supreme Court, essentially asking them to apply Belton. Look, you guys made it pretty straightforward in Belton that we get to search the car every time, and our court is not following your rule, is basically what they said. And the U.S. Supreme Court took a moment to say, well, wait a minute, maybe that what we said in Belton wasn't entirely the circumstances that have come out since Belton wasn't what we meant. We realized we might have gone a little too far with the language that we used in Belton. So we're going to revisit this search incident to arrest authority, and we're going to change the rules actually quite significantly, the court said. So now what we have today for vehicle searches incident to arrest, we can search the vehicle under one of two circumstances. If one of these two conditions exists, then we may do a search of the passenger compartment of the vehicle. One is if the arrestee is unsecured and could access the vehicle. Then we can search the compartment to make sure there's no weapons or evidence that he might destroy. Now, I don't think we have to think long and hard about why that situation probably wouldn't present itself very often, because the guy we just arrested, the first thing we normally do if we're following police procedure is we secure him with handcuffs, and then we do a search of his person. And then if it's a roadside stop, he goes in the back of a police car. So he's pretty much.
Can I jump in here real quick and ask you a question?
Yes. Mm-hmm.
If you have, let's go back to a passenger in a car. He's got a backpack at his feet. You take his information. Maybe you can compel it because he's not wearing a seatbelt. You run him for warrant checks. He ends up having warrants for his arrest. You're going to service the arrest. You take him out of the car. Do you get the backpack inside the car as incident to arrest as his personal property?
I don't believe you do, unless that backpack's going with him to the jail or the detention facility. If it's remaining in the car and we don't have any reason why we would need to take that backpack with him, I don't believe that's going to be part of the search of his person incident to arrest. Now, it could be a search of the vehicle, part of the vehicle incident to arrest, but I don't know that we would automatically get to search that backpack. Now, if he was walking down the street wearing that backpack, yeah, we could do that search incident to arrest.
Or maybe in a public transportation setting because nobody's taking it.
Somewhere where we couldn't just leave the backpack in the vehicle. I'm assuming we probably would be able to leave it in there. So I don't know that we get to automatically search that backpack.
You know, I read a piece of case law a while ago, and I think there's something in Jersey regarding this. But man, it's been a while, and I know this has been tested because it's been done. I think in this state, it is so obscure. A lot of people probably don't know about it, but I can't even really cite it or know what the result was. I thought it, but again, I'm not going to go down that path until I can figure out what it was. And it may be a while before I come across that one. But for now, what you're saying is you don't agree with the idea that they could, you know, let's switch it up. What if it was the driver and the pocketbook was in the car? It's a female. Nobody else is in the car. Would you get to search that pocketbook incident to arrest? Is there any difference with that?
I don't know that necessarily. Well, I don't know the position in the vehicle. The person's position changes that analysis any, but I would imagine if it's just the driver and sole occupant, there's probably going to be another basis for searching it. Maybe an inventory of the vehicle if we're going to tow it.
Mm-hmm. If you're not going to tow it, you're going to park it.
If we're just going to leave it there, I think we would probably still, if we're going to leave the vehicle there and she's okay with it being left there, can't think of a good reason why we would be able to search something that's not on her person at the time we arrest her. Now, if we had a reason to believe that purse contained evidence of what we just arrested her for, then yes, we could clearly search not only the purse, but the entire passenger car.
Wow, look, it's leading right into number two.
Right into number two.
Yep. Arizona began. Go ahead.
Yep. So the unsecured arrestee scenario is probably not something that's going to occur with any kind of frequency in a vehicle roadside arrest situation. But that's one of the traditional justifications for search incident to arrest. That's why the court addressed it. But then in Gant, the court kind of went way out in left field and came up with an entirely new reason for searching a car incident to arrest that they've never mentioned before. And that is for evidence of the crime of arrest. And so we could search the vehicle passenger compartment now if we have a reason. The term the court used was a reason to believe there is evidence of the crime of arrest, the specific crime the person was arrested for. If we have that belief, we can now search the entire passenger compartment of that vehicle, regardless of where the person was seated, or if there are other people in the vehicle and the vehicle is going to be released. It doesn't matter. If we have that reasonable belief, we can search the passenger compartment.
What's a circumstance where we would find ourselves, and let's be clear, because people ask me this question, and I'm going to say it before I ask you the question, because I try to volley a lot of stuff to you and play the person who asks a lot of questions in class, which is great because that's really how we tailor our programs. We're constantly collecting data, what people are confused about, and then we're making sure we cover that stuff in class. And, 9 years doing my program, that's where I've come to with the answers for things. People ask me off the wall, oddball shit. And I'm like, yeah, listen, I can give you what I think, but I'll have to research a little bit. People will say, well, what if they have a warrant for their arrest for possession of cocaine? Can we search for possession of cocaine? And you know the answer to this, and I do too. it's not a fresh set of circumstances. It's a pre-existing, circumstance for the possession of cocaine. So you wouldn't get the authorization to look for that narcotics inside the car without a new, fresh set of circumstances. And on a quick side note, since we're kind of going down this rabbit hole just a hair, well, look at that. No pun intended, but it ended up being a good pun. People will, or was I? Let me back up a little bit. Here's where I want to go. One tactic that I've seen a lot, and I don't know why people do this, is they ask for people's criminal histories on traffic stops verbally, not using the computer without the justification to access CCH. But what they'll say is, have you been arrested in the past? And then people start to formulate how they're going to approach the situation based on the person's history. That's a really bad idea. Now, what I can tell you that people ask, well, does that ever count in circumstances when we have reasonable suspicion? Yes, when you have already independent reasonable suspicion fresh to this particular incident, maybe you're at number 17 on our checklist of how much reasonable suspicion you have, and you're going, all right, something is definitely wrong here. This doesn't make any sense. They're nervous. All these things are happening. And now we look at their criminal history. Does that count towards something? Yes, it does.
Absolutely.
But you cannot begin your criminal investigation based on somebody's criminal history or their response to it. Because what if I tell you, yeah, I was arrested for distribution of marijuana in the past, but maybe that past is 21 years ago when I was 19. Now I'm 40 years old. So just so people are clear, when you're asking that question, we actually got a case out of New Jersey where that happened. It wasn't the guy's fault. I talked to the guy. His field training officer taught him this tactic. And he ends up finding the guy says, yeah, I've been arrested for this. I'm on probation. So now this dude starts getting suspicious. They call for a dog. The dog indicates, and he finds a handgun in the car that this felon in possession of a weapon had. And it makes its way up to actually, it's one of the only ones that I know of where our circuit court heard that here. And they got a ruling at our circuit court beyond the state Supreme Court here. It went to our appellate, our state Supreme, and they appealed it up into federal court. And I don't think it went beyond the circuit court, didn't go to district court of appeals. They get stopped there. They just said, all right, enough with this. I don't know why they continued to appeal it. I'm guessing the prosecutor thought they had a real strong case. But it was from the get-go crapola. And when it came out, of course, people were like, oh, did you see this came out? I'm like, well, yeah, when you ask somebody if you've had a criminal history and you start to now formulate how you're going to approach this circumstance on this traffic stop and then find it, you got problems there. So just understand it counts towards something. It's just not everything. And you're not going to build your foundation off of that. You're going to want to have a fresh set of circumstances. Would you agree with that?
It's yes, I would. It definitely cannot be the initiating factor. So a person's prior criminal record, however you obtain that knowledge, maybe it's personal knowledge you already have, or you run a formal records check, that can't be the sole basis or the initiating basis for a stop. Just because you have been arrested before does not subject you for the rest of your life to being detained every time the police come across your path to find out what you're up to. It can be a factor after you've developed some kind of suspicion about criminal activity now. Mm-hmm. Yeah, I agree with what you said. Absolutely.
Okay, so we'll back up a little bit, back to Gant. Circumstances where Gant would apply, I already discussed that it was pre-existing on a warrant. That's just because the circumstances of the warrant were maybe possession of cocaine or heroin or whatever it may be, or theft of items, or credit card fraud, whatever it might be. That's not going to trigger your ability to search the vehicle incident to arrest because it's pre-existing circumstances. So go ahead.
The outstanding warrant. I mean, think about how many, thousands of people, tens of thousands of people get arrested across this country every year on traffic stops just because they got outstanding warrants. Well, pre-Gant, we were searching those cars every single time. That was probably the biggest loss of search authority in this category of arrests. And so the Gant evidence collection branch, which is what we're talking about now, it specifically relates to the crime of arrest, the facts surrounding that crime. And a possession offense, like a narcotics possession, where a warrant's been issued, that offense it's over. It's the possession of that particular cocaine or whatever it was, that occurred at some point in the past. There's no evidence to be collected of that offense right now. It's not the fact that, well, he's got a cocaine possession warrant, maybe he's got more cocaine now. That's a different offense. That's not
Hmm.
a crime of arrest. So yeah, the warrant based arrest authority is gonna be almost it's gonna be very rare unless you
What
know
if
some
we have
very facts.
what if we have a warrant, take the guy out, execute it? I think I asked you this last episode. We now search his pockets and we find 3 bags of cocaine in his pockets. Is Gant going to kick in, or are we into a probable cause
Oh yeah,
search of the vehicle?
we have moved past Gant now. We're now well Gant does apply because it's Gant applies, but
You have fresh charges on
yeah, you
cocaine.
got a brand new you got a new offense, a possession offense occurring now, and it's reasonable to believe there's more of that evidence of this crime in the vehicle. But remember, Gant limits you to the passenger compartment. These facts also open up an automobile exception. You've got probable cause to believe there's more drugs in the vehicle, so that allows you to search the entire vehicle, including the trunk. So yes, Gant does give you that authority, but we would rely on the automobile exception in that case to go even further, a further in-depth search.
I just had a vision of you and I in my backyard because I'm getting like some work done. I just bought a nice like stereo system for the backyard. I mean, really nice stuff. I got a guy coming to do the lighting. Really trying to set the mood out there, Zach. And I think me and you, not that I'm a heavy drinker, but maybe we could just nurse some, like apple cider beers, just
There we
one
go.
summer day, and shoot the shit all day about thoughts and things and all that stuff. That's how I see myself with you. And I don't want to put us on a yacht. I'm talking 2 guys. You got your southern accent. We're in the backyard. It's about 84 degrees out. We got the canopy out, and maybe for lunch we order some nice Italian food from John Marco's down the road. You know?
I think there's plenty that we could discuss. This is
Yeah. You're going to come up for the party in June, right?
if I'm invited, yeah.
You have to. You have to. I'm going to cover your hotel expenses, so
And
I can only fit so many people in the house.
To.
I got the Kenny Williams and his wife are staying in my house. I don't know unless you want to camp out in my basement. I don't know if it's going to start getting weird if I start. You want to sleep on twin beds in the other kids' rooms? I mean, you're 6'3". You're going to look ridiculous.
Well, if Kenny Williams is going to be there, that's good enough reason to come there.
I love that.
Looking forward
That's
to meeting
good.
him.
Yeah. No, we're going
to
to try to have every instructor that we can at the party,
Good.
and then we'll have the whole staff here too. So we have 20 full time right now at this current junction. Everybody will be there as long as they can make it, except for Becca because she's prego as shit right now and she's ready to go. She actually took off early today because I think she farted, got nervous, and had to run off to the doctor to check. And she's going to hear this, and her husband's going to crack up. But yeah, she ran. Yeah, first time pregnancy. She's everything that happens. She's got to go and make sure that everything's up to par. But anyway, back to the Gant thing. So cool. What are some examples that you've seen? And what other ones can you imagine where Gant would actually apply?
I think DUI and a DUI arrest is the quintessential example of where this would be a good search. DUI is certainly the type of offense where you could expect to find or be reasonable to believe you could find evidence of that crime in the vehicle right now. Maybe a larceny offense, an ongoing larceny. Where let's say it was a shoplifting and you responded to the scene and the vehicle had got a vehicle description and stop it a short distance later. Absolutely evidence of the larceny. So there's lots of cases where it could apply. Maybe in an assault and battery that involved a weapon or a brandishing of a firearm case. There's lots of them.
I feel like Gant and the automobile exception almost run side by side almost.
They use very similar language and the main difference, the 2 main differences are the justification for the search. The automobile exception requires full probable cause. Gant, I'll talk about the justification here in just a second.
Cool.
It's more than just the arrest. And then the scope of the search, Gant is for one reason or another, the court chose to limit it to just the passenger compartment, this evidence collection branch. But as we know, the automobile exception extends to the whole vehicle, but they're both searches for evidence. So they're very similar. And a Gant search can very easily expand into an automobile exception search depending on what you find in the passenger compartment.
I'm going to jump in here real quick and just want to remind some people in a handful of states that there have been limited scopes to search at your state level. So if you're hearing this, and I know that a lot of you inherently trust Zach and I and our legal opinions, namely Zach more than I, just bear in mind that states like New Jersey, Ohio, and Pennsylvania are going to have some limitations, but they're usually, and if you could agree with this, I don't know, they're usually limited in drug possession cases. That's the only time I really see them. We actually have some language, if you read some of our law, that talks about, the fruits, and the people come up with their own formulations of what they think flies and what doesn't. But overall, you're going to find yourself in circumstances here where the whole car is going to be yours. But just bear in mind, for some states, you may have limited scope. You just may have to do a little bit more to get into those areas beyond what you're allowed to search.
Are we referring to states that limit Gant or Central Search Incident to Arrest Authority? Because there are some.
Well, I'm also talking about even finding, let's say you do a Gant search, maybe in Ohio, and you come across probable cause to search the car, and maybe it's a small amount of marijuana. Okay. In Ohio, you're not going to be going into the trunk or under the hood of the car.
New Jersey too, right? Aren't your trunk limited in New Jersey?
We do, and they're limited to intoxicants generally is how it goes. So small amounts, ideal, even with the legalization of marijuana now, and it's on the forefront, it's happening in August. I don't know how they're handling marijuana smell cases. I haven't had time to review, and the guidelines that keep coming out keep changing. But essentially, what they look for is dealer size quantities is one of the languages they use, or reason to believe something larger was being found, namely when we talk about narcotics, beyond the interior compartment of the car. So you have to kind of elaborate why you got to go beyond the interior compartment when it comes to narcotic related stuff. And obviously alcohol is almost never going to transfer to the trunk, because we're always going to do an alcohol search for intoxication while you're driving.
Right. And there are a few states that do limit Gant, that don't, under their state constitutions, don't permit the evidence collection branch. All states allow if the guy could access the vehicle search, but we're not going to have that situation. And so I know Iowa is one state that there is no Gant search incident to arrest for evidence. New Jersey as well, right?
Unless yes, that's correct. We have no access,
right?
Well, so we can search cars for intoxicants when we have a DWI, whether it's CDS or alcohol related. However, they said we don't have an automobile exception. What this is this establishes problem when somebody's drunk after you give them SFSTs and they fail, and you've made a probable cause determination to arrest and transport to headquarters for further evaluations and processings. That is probable cause to search the interior compartment of the car, but it's not a search incident to arrest.
So it's a probable cause.
Yes.
Okay, which is different than Gant, right?
That's right.
And Washington State doesn't allow them as well.
I'm going to jump in real quick and ask one more question, because these things are turning up that people ask me these questions all the time. Briefly, we touched on, and we'll do this for another program. We touched on inventory searches. If you are doing a lawful inventory search, this one just came across the other day, and you find some probable cause, does that now turn into a PC search where you're allowed to search the entire car?
Yes, absolutely. Yeah.
Okay. And the reason I say that is because we have to understand, as police instructors, especially when we talk about legals and legal topics, there are a lot of people who are very, very confused on a lot of this stuff. And I want to be very clear. There are people fighting the good fight against administrations. There are administrations fighting the good fight against politicians and maybe other legal representatives. So having good, clear understanding of what the action they're taking and why it's proper, that's what I'm trying to cover when I ask you these follow-up questions. I know the answers. I'll let you know if I don't. But I wanted to make it clear that you're hearing it from this expert. You could trust it. And I said to everybody all the time, and I say this again, I just had a guy write to me before. They're having an ongoing debate. He was provided at the police department. They were provided with the law and my explanation of who's right and who's wrong. And he said, some people still don't believe it. I go, that's fine. But what I'm going to ask in return is for you to provide the legal documentation that contradicts the legal documentations that I've given to you. So I have where it says 3 times over that I'm correct in the advice that I'm giving you. Just show me where it says I'm incorrect. And until you can find that, in my opinion, the conversation's over. Your opinion on case law or the way things should be done and how you're making sense of it in your brain, it doesn't fucking matter, because some of the stuff doesn't make sense if we actually looked at it from a legal. Sometimes we're surprised. We're like, wow, they gave that to us? Holy shit. Like, we'll take it, but we're surprised at that. Sometimes the other end of the spectrum occurs. Why wouldn't they let us get that? That makes no sense. Why would they rule against this? So without further interruption, good banter back and forth is great for this podcast and this platform, but I don't mean to interrupt you. Carry on, my 6'3" friend.
So I guess the rest of Gant, we taught, so it's an evidence collection, the evidence collection branch, where passenger compartment, evidence of the crime of arrest. The court, one of the areas, so Gant is a relatively new case. It's 12 years old, but it's still relatively new, 12 or 11 years old. It's still relatively new in the fact that courts are still trying to figure out, lower courts are still trying to figure out the full breadth of Gant. And what the main or the predominant issue that Gant has left unresolved and the courts are struggling with to a degree is, what did the Supreme Court mean by the term reason to believe there's evidence of the crime of arrest in the vehicle? And there's two competing points of view that have kind of taken their place. One of them I think is right, and the other one I think is it just can't possibly be correct. What does the term reason to believe mean? Well, when the Supreme Court traditionally uses that term, they use it as a synonym for probable cause. But we know right off the bat, and courts all agree, that doesn't make sense. If we substitute the word probable or the term probable cause for reason to believe in this statement, it makes no sense. If you have probable cause to believe that there is evidence of the crime of arrest in the vehicle when you search the passenger compartment, that's just a restatement essentially of the automobile exception with a passenger compartment limitation. So that makes no sense. The court would not have given this new authority for a search for authority that already exists. So we know it doesn't mean probable cause, so it means something else. The one view is that, well, maybe it means reasonable suspicion, because they actually did use the term reasonable belief in Terry versus Ohio numerous times regarding the authority to frisk. That's one view that some courts have taken, and I believe that's an incorrect interpretation, because the U.S. Supreme Court has never authorized an evidence collection search on less than probable cause. Reasonable suspicion will only get you a protective search, a search for weapons or dangerous people or items. So that's why I don't think that the reasonable suspicion test is the correct one. So what it really means, what the other view is, and I think this is the correct view, is it's what's called a nature of the offense test. So it is a probable cause based search, but where does the probable cause come from? It comes from the arrest. And so another way of phrasing it is this the type of crime that you could expect to find evidence of in a vehicle? I don't have to have a particular reason why I think there are alcohol containers in this vehicle on a DUI arrest. All I need is that DUI is the type of a crime that you could expect to find evidence in the vehicle, and then Gant would authorize that search. I believe that's the correct view.
Let me ask you this. Under that logic, and again, not to get off topic, when we talk about, and I'm going to a whole different realm, but the language sparked interest to me. We start talking about the entry into homes under the existing warrant in hand, Peyton v. New York / what's the other one?
Seagull versus United States.
Seagull versus United States. They, in the language there, what do you interpret that reasonable belief to believe the person's inside? Should that be probable cause as well?
See, they that's the term they use, and lower courts struggle with what that means. And I would probably say the majority view is most courts think that means reasonable suspicion that the person is in there. I don't believe that's the correct standard. I think it has to be probable cause. We're talking about entering a home to effect an arrest, which is a significant intrusion. I don't know that reasonable suspicion is the factual justification required under the Fourth Amendment. I think probable cause.
I think some people are able to I get the question all the time. That's a big one. People ask me questions about, what do I need to go in? I said, well, listen, do you understand what probable cause is? The person's probably inside, if that makes sense to you. And you could disagree with it if you, and my definition, I try to keep very simple. We are not here to make a case of proof beyond a reasonable doubt. So what do I need? People say, well, his car's in the driveway. Yeah, I don't think that's going to do it. How about his car's in the driveway? The neighbors called, knew you were looking for him, said they saw him go inside. You got 3 independent neighbors that corroborate the same story. and say, he went in, we saw him. He actually said to Joe across the street, let me know if the cops come. I got a warrant. If they know I'm here, they're going to run into the house. You have, and we're talking about different circumstances here. So you're going to need more than just, this is his house, this is his warrant, we're going to kick the door in. When you start having reasonable belief / what in our opinion is a lot of objective factors, maybe equaling probable cause to believe that the person's inside, maybe even spotting them inside, but just guessing because you see a male figure, there'd have to be a lot of circumstances. And it really does come down to the police officer in the field to collect the data that they have. And you have to make an independent analysis on what you're going to do and what the circumstances are. How dangerous of a situation is it, right? It's a lot of things to take into account. What's the warrant for?
Probable cause is really not that high of a standard. It's just,
right.
It doesn't even have to be statistically more likely than not the person's in there. So probable cause is not a 51% rule. It means different things in different contexts. It just means, is there a good chance that this guy is in the house, if this is what we're talking about? Is there just a good chance there's evidence in this location we want to look? It's more than speculation. It's more than a guess. But yeah. The scenario you gave where, we're talking to the neighbors and they tell you all these things about him being in there, we're looking at probable cause in a rear view mirror in that situation. I mean, we're way past probable cause in that little scenario.
Yeah. And people really need to, they really want to pile it on to make a decision.
Mm-hmm.
And that's it. We get it. And you have to understand, and I understand this, we are fortunate enough to understand what a lot of this stuff means and how to apply it. And now, because of the research and practical time in the field, we're able to employ these principles quickly and make rapid decisions or give rapid advice. And so is Ken Rice, who's our New York legal instructor. He's in the field guiding, I don't want to say the agency because I don't play that game here. I get that it's very different when you've spent zero time, or maybe you're in some kind of dyslexic way, having a hard time understanding and interpreting it and want to play it safe. But, so we're aware that we are trying to make it as clear for everybody as possible to understand what we're saying when we're talking about those things. Zach, do you think we're done with the Gant thing? You want to move on to the next one?
Well, I think we've covered. I mean, certainly if people have questions, you give me an email address, zach@streetcop.com. I answer all emails. We may not talk about it on air, but if you have a particular question, I'll be happy to answer.
You are opening Pandora's box, my friend.
I might not answer it on the day you send the email. I mean, I'll get to it eventually. But yeah.
Unfortunately, this is a real thing, and I'm glad that people are listening to this and we're bringing up this topic. It has just come to a point in my career where if I answer your emails and I'm not trying to sound like I'm hot shit, you got lucky. I don't have time to sit all day while I'm running this company, and people know how big it has gotten and where it's going. I mean, we have just exploded at this point, and we have extreme momentum forward. And I had to make a decision on, am I going to spend my days answering emails, or am I going to spend my days running and growing this company and unfortunately, one person may not feel like they were served, but in the other side, hundreds or thousands of people will be much more served. And that's a hard decision to have to make when you're a business owner, on beginning to prioritize, especially when it means so much and you've built the company in the back of being so responsive to people. So if you have emailed or messaged me on Facebook, eventually maybe I'll trickle around to it. Addie, who's my executive assistant, she'll go through the emails and try to handle all the ones that she can. Sometimes I see 6, 7 legal questions. I may pick one that's maybe easy. People are getting me state-specific stuff that I don't want to give improper advice for. So just some food for thought there, guys and girls. If you are sending me something, you haven't sent something back, your better bet is to send it to streetcoptraining@gmail.com, not my personal email address. Because sometimes I don't even open it for a week. I just don't have the time for it. And it's really actually a superpower to be able to do that shit. But Zach, you're asking for trouble because you are on your way up as a rising star here. What I would do is maybe cherry pick some stuff so we can discuss it. But I also listen to what's going on and the constant same conversations that are going on throughout the country where people are miscommunicating or misunderstanding how to apply proper precedent in case law. Let's move on to our next topic. And that topic is
inventory searches. Right?
Let's back up a second.
We're going to do the search incident to citation. Knowles.
Let's do inventory searches next week.
Okay.
Let's do search incident citation. We can do it this week, but let's just stop a second and The question I get this all the time. And I'm going to give you our New Jersey answer. I'm going to hand it over to you for a Fourth Amendment answer, which will apply to which far majority of people here. After a pursuit, can you search a car? And here's the Jersey answer. And actually, maybe you'll help me understand it a little bit as well. The Jersey answer is, and actually I'll parlay it to you with the intention of not sounding like I don't know what I'm talking about, because times have changed just a tad in New Jersey compared to what it was when I had it and we didn't have the automobile exception. In New Jersey, we actually don't have a bright line rule on searching a stolen motor vehicle, which is crazy, right? So there was one case that came out where the car had been stolen 6 months earlier. The person inside the car, who was a passenger, did not know the car was stolen. Everything was searched. CDS was found inside their pocketbook, I believe, was a female, and she suppressed it. And the court said she didn't know the car was stolen. She still had a right to privacy. Many states have adopted a bright line rule that everybody in the car, there's no right to privacy. Basically, in New Jersey, if you have a hot, fresh stolen car and it's clear as day they know the car is stolen, this is one of these cars that was like rented in the hood, right, for $30 a day, passed around until somebody finally caught on and there was a traffic stop and they ran the VIN and found that it was stolen. Maybe somebody had an inkling, inkling's not the word I'm looking for. It's Friday. I'm getting burnt out. Or had some clue, but didn't actually know the car was stolen. There is no bright line rule for it, but generally, when you have a stolen car in New Jersey, overall, in 99% of circumstances, the car is going to have no expectation of privacy. But just understand that there are circumstances where it may not. In New Jersey, a pursuit is a second-degree felony, graded the same as an attempted murder here. So first degree is a murder, second degree is attempted murder. We have second degree kidnapping, second degree aggravated sexual assault. It's a high crime here. It's very, very high. It carries, I think, 10 to 20 years prison time. I think our felonies, the high felonies it could be 10 to 30, but I know the high felonies are 25 to life, which is a first degree crime. So it is a crime when you flee from the police. Once you start getting into that criteria of you're in a pursuit, you now have a second degree crime. And I'll let you take it from there. With that being said, what would be your advice in New Jersey to start? Then you can go into the 4A thing.
Well, it depends on, not every vehicle pursuit is a stolen vehicle. I would think that if it's a stolen vehicle pursuit, the vehicle itself is evidence of the crime. That by itself, under the Fourth Amendment, subjects the vehicle to being seized and search for evidence of that crime, fingerprint evidence, searching the belongings inside the vehicle. I don't think that if the fact that it's stolen, I think that's as close to a bright line search as you're going to get. But
it's almost bright line in New Jersey, right? It's almost bright line. The question is, what if it's not stolen? What if it's a dude who takes off on you?
Right. He's got a suspended license, or he's got a warrant or something, so he takes off. I would imagine in every state, it's at least a misdemeanor, a high-level misdemeanor, to run from the police on a traffic stop, if not a felony. So we finally catch up to the car, whether it wrecks or he just pulls over. We get the guy out of the car. Can we search the car? And just because you're pursuing it, no, you can't search it just because it's being pursued. You're going to have to revert to the traditional reasons for warrantless vehicle searches. If I've got probable cause, believe there's evidence in it, then I can do a automobile exception search. Depending on the nature of the circumstances, we could maybe do a vehicle frisk of the areas that are immediately accessible. I would be inclined to think that probably most courts would allow at least a vehicle frisk on pretty much any time you stop the vehicle. I don't know that I would agree.
In a pursuit.
A pursuit.
Yeah.
Pursuit.
Okay.
Yes.
Now, it's a second degree crime in New Jersey. So you get the car stopped. Let's say he does wreck out, blows a flat, breaks an axle. Let's slow down here. Let's just say it's a pullover. He bails out. He runs. We catch him. We've got evidence of a crime here of second degree. We're going to be building a case. This is part of it. Would you think we'd be able to search that car in New Jersey, knowing that it's a second degree offense? We have met the criteria for second degree
as evidence of the crime that you arrested him for, or
either or.
Yeah, I don't know that the vehicle itself. If someone is running, are you saying that it's a second degree felony just to flee from the police? Okay, so.
Oh yeah.
We don't have to prove why he fled, so I don't know that the vehicle search would provide any evidence of that particular crime. But I'm almost willing to bet that almost every time we're going to be towing this vehicle. You know,
Oh yeah.
I'm
Or
assuming.
and by the way, we are going to at some point process it. Do you think it would be a better idea to apply for a search warrant in these circumstances?
No, because you would need probable cause to believe the vehicle is either evidence of or contains evidence of a crime. And if you have that probable cause, then you do an automobile exception search. So
Right.
there's no. I guess the only time you would apply for a search warrant, in my opinion, for a vehicle search is if you're questioning the existence of probable cause. If you're not certain that you have the probable cause, you need to search it, and you want a judicial official to weigh in on it to solidify the basis for the search, then certainly. But if you know you've got probable cause and you're covered by the automobile exception, there to me is no reason to get a warrant.
The pursuit itself, let's call it. I'm going to really make it very, very light. Even though it's a pursuit, it's a very serious offense.
Mhm.
It's the guy's car. He didn't feel like going to jail today. Maybe he's a bag of nuts, right? He's a little bit of an EDP.
Right.
You don't want to stop. Now we're on a 16-mile pursuit. This thing crashes out. He gets out of the car, maybe even surrenders, lays down, puts his hands behind his back. We cuff him, bring him in. Are we searching that car after that pursuit, after the second-degree crime occurred?
I don't think we're searching it just because of the pursuit.
Okay.
So if it crashes, we're going to tow it and do an inventory.
Well, we don't get tow and inventory in New Jersey.
Oh, there's no. Okay. All right. Well,
Nope.
there you go. So there's a big.
So we're just going to tow it and let it sit. And what do we do? Let him get his car out if he legally returns back to get his vehicle.
If you've got a reason to believe there's evidence in it, then I would think you certainly could search it.
Right.
So I think you can at least frisk the immediately accessible areas looking for weapons.
So you'd have to apply what Zach is saying here. So if you had a pursuit, maybe you had a pursuit, and the guy you got to get a little bit more than that, right? So you got to have, maybe it's a pursuit after a drug deal that he was spotted.
Right.
Right. That makes sense. Like, your guys are narcs watching a car. He knows he's spotted, takes off. He's on a pursuit now. A little different. You had a setup for him. Right. Are we running into it then? The guy maybe discarded something out the window during the pursuit. What do you think?
Yeah, and that now we're getting to some specific facts and circumstances. It's not the pursuit by itself that's authorizing a search. It's all the circumstances surrounding the pursuit.
People will ask that. They will say, we get a bailout. They run from the car. Can we search the car? And I always have given advice of no, unless you're in Wisconsin. And Wisconsin actually says, if you abandon the car, it's abandoned property.
Yeah, and I think that's a little bit of a stretch from a Fourth Amendment standpoint.
How cool is that, though, right?
You know, if that's
one of those ones that, hey, Wisconsin, God bless. You got that one. It says it there. I read it. I think did I send it to you?
It sounds somewhat familiar.
You bail out on a traffic stop and nobody's left in the car. You've abandoned it, like you've thrown a bag to the side in a foot pursuit.
Wow.
Yeah, it's good stuff.
Yeah. So
they got very good case law in Wisconsin. There are two states that I could tell you right off the top of my head as we're talking, Rhode Island and Wisconsin, where they almost are their own U.S. Supreme Court at times, where they're saying, man, you know what? They say this. Like, Rhode Island really gives the benefit of that to the police over and over again. So does Kentucky's another good one. Rhode Island gives the benefit of that to the police, where they're like, he sneezed and he scratched his ear. We felt that was reasonable suspicion to believe the person was armed and dangerous. Wow. That's a nervous tick. They do cool stuff like that, where then you go to Massachusetts, like, he only told the cop he was going to slit his throat, reached for his waistband, and has a criminal history that they've known of carrying guns 17 different occasions. We did not find they had reasonable suspicion on this occasion. That's a whole different set of circumstances. And it's literally a stone's throw away from Rhode Island. So let's go into, now we've talked about that one. That's a good one. People ask me that all the time. Let's wrap it up today with this search incident to arrest, Knowles v. Iowa. What happens there? And the reason it's brought up is because of this COVID-19 pandemic. What police officers are being instructed to do is, we are not taking people to jail. We're not people in our cars. We're having minimal contact. And a lot of times for whatever the circumstances may be, we're going to be issuing a summons and referring them to the court.
Yeah, and that's fine if you want to do that, but you lose search incident to arrest authority. I mean, and I get this question a lot too, and it's not really something I got to think really hard about. If there is no custodial arrest, and that means we're putting him handcuffs on him, putting him in the back of our car, and we're driving him away to either a booking facility or detention facility. If that's not there, If it's an on-scene cite and release, there's no search incident to arrest. There's no automatic categorical search incident to arrest. So it's a search incident to custodial arrest that we should really be referring to it as.
So you would need custody first in order for that to come into play.
If you're calling it if it's a search incident to arrest, yes.
So people will say to me, okay, we have we know that this warrant's non-extraditable, but we're still checking it. Do we get to arrest and then search them incident to arrest? And what if they come back and say the warrant is not extraditable? I go, well, now you're getting to the area of good faith. And is that a good faith exception where you already knew that they weren't coming to get him, or you had 17 arrests prior to this where you were told, if you run through these circumstances and you've done it, you performed it, that they're going to be released roadside or whatever it may be on scene. They're going to be released with a summons. You can't say, well, we didn't know if we were going to do it this time. Good faith, good faith. It doesn't work like that.
The term good faith is thrown about without a whole lot of meaning when it comes to Fourth Amendment search and seizure law. Good faith is not the same thing as honest mistake in civil law. There are good faith exceptions under the exclusionary rule, but they're very specific circumstances, like a search warrant issued, a facially, it looks like it's a lawful search warrant, but there's a defect in the warrant that a reasonable officer would not necessarily notice. That's an example of a good faith exception. It's a defective warrant on its face, but a reasonable officer would not find it to be defective. Then it's still a lawful search. There are clerical error, good faith exceptions, but there's not just some general, well, I thought this is what I was allowed to do, so I'm good to go. It doesn't work that way in the exclusionary rule. But yeah.
When would you be able to, in these circumstances, if you know a citation is being issued, would there ever be a time if somebody was technically quote unquote arrestable, but we know we were rolling into a citation where you would get search incident to arrest, even though they're going to be cited and released on scene?
If there is no custodial arrest and we're just issuing a summons or citation, Knowles versus Iowa was a on-scene citation case where the officer actually searched the car and found drugs in the car, and he called it a search incident to arrest because Iowa law allowed it. He was following the law in Iowa.
He said he could have arrested because he could have. He thought he could search because he could have.
He chose to issue the citation, then he did the search. So the Supreme Court said what Iowa was asking the Supreme Court to do is extend the bright line rule to, well, even if we do issue a citation, we're asking that, well, it wasn't an arrestable offense, so we should be able to do a search incident to arrest every time. And the Supreme Court said the bright line rule for custodial arrests, we're not going to extend it to citation offenses. But it didn't, what the court did not say was that you could never do a search incident to citation, if you will. If you had a reason to believe that the person had evidence of the citable offense on their person, I'm of the opinion you can still search their person and call it a search incident to citation. But that's going to be a rare circumstance because most of the things you issue citations for, trespassing, driving suspended license, those kinds of things aren't things you're going to find evidence on their person.
Well, there's been a lot of prosecutors nationally that have issued orders that even if it's something that is major, they're putting things on summonses during this pandemic, and it's just specific to this time. And some of it may stick. They might have actually found some things where they're like, hey, this has worked out great. Why the hell would we bring people in for this stuff in the future? Let's just keep rolling it out. Even in New Jersey, we are actually allowed to put, I think we can put third and fourth degree charges, which can be pretty significant, even on summonses. People don't know this, and I don't want to be misquoting it, but I believe it's third and fourth degree on our special state summonses and release from the scene. I don't know if you can use them for those. Maybe you can't. I think you still have to bring them back in processing. But what they're probably saying is, look, you got a fourth degree shoplifting and it's over a certain value. Issue them summons. We don't want them back at headquarters. We're not lodging people for a $1,300 laptop that was stolen. It's not an offense. It's not a high felony here. It's a low felony, and that's what people are running into here. So you roll up to Best Buy, the guy maybe used or as a shoplifter, They come out. It's a shoplifter. You start the processing for a summons on scene.
Mhm.
Do you get to search him incident to arrest, maybe for like shoplifting items?
Yeah,
Like,
if you have if you know this guy's going to get released right here with a summons, but you have a reason to believe that he's got evidence of whatever it is you're summoning him for, citing him for, then yes, I think you can do a search incident to citation for that evidence, and then release him on the citation. Unless
almost like a Gant for a person.
it's essentially the same thing. Yes, and the search for evidence is one of the traditional rationales for search incident to arrest in general. But with custodial arrest, it's just a bright line rule. They get taken to the jail or wherever, you get to search them every time. You don't get to search them automatically for the citation. But that's the drawback. If we're going to decide to release more people on citations, then there's going to be less searches incident to arrest. That's the trade-off.
It is a trade-off. And, I often tell people, look, they don't have a kilo up their butt. So people get very frustrated. I know she had it on her. Okay. And I think I've said this in the past, and I've heard it I can't even take credit for it. One of the instructors in New Jersey is a well-known guy. And I don't want to say his name because I don't know if there's any copyright issues, but he said, if they got it up there, let them keep it. That was his rule. And, to try to go for body cavity searches to find a gram of crack cocaine, sometimes you have to know how to pick and choose your battles. And I would tell people, look, we searched this car really well. We knew something was wrong. We did as much as we could. I'm looking at this girl. Do I think it's somewhere up somewhere? Probably. But I'm comfortable knowing I'm letting them leave here, doing the best that I could, and clearing the fact that I know it's not 2 kilograms and 150,000 in cash or a stolen handgun. We would have seen that. Do I think she has 3 bags of heroin up her butt? I do. Am I going for it? Have you seen this girl? You don't really get runway models hiding heroin up orifices of their body. So we're just not going dead. Sometimes you got to just accept defeat. And by the way, you don't want to swing and miss on one like that. That's when you're asking for some real trouble.
Right.
Yeah. So, people can't get frustrated. This is the same guys that are like pulling over the same drug dealer over and over and over again. This is the 6th time this week we're stopping Jimmy. Every time we stop him, he comes in and complains. I'm not dissuading you from doing your job, but there's some things that you do as a police officer and perform that you're asking for trouble. And there are bigger fish to fry in this world, and you have to understand where to pick and choose your battles. And some days you come back and win another day. And if you have it up your holes, I'm not trying to find them, right?
It's probably not the first time it's been there, and it probably won't be the last, so we'll get them next time.
Yeah, and let them smoke their own whatever sense coming out of those things.
Yeah.
I don't have much else. I have a question, but we'll hit it next week. And I want to discuss, I think we talked about one of our last episodes, what to do in a right to identify state. I'm going to run New Jersey past you and what your opinion is. I'm actually going to call you after this.
Okay.
Just to see what your thoughts are and if my advice jives and how you would, because I don't have it in front of me and I'd have to explain it to you. And I don't want to start this conversation. I have all the factual data in front of me. And then we have to stall while people are listening to this, maybe running on their treadmill or walking their dog, whatever it may be, waiting for me to sift through some documentation on the internet to have the conversation. So without further ado, guys, this is the Street Cop Podcast. If you like the stuff that you heard here, check out streetcop.com. Follow us, give us a review, tell your friends. We have a lot of upcoming training in the future. The Street Cop Conference is outrageous, streetcop.com. We have a huge crowd so far. I'm really excited about that one. It's going to be really good. Dude, you got to see some of the stuff I'm putting together. We just had our entertainment companies like, you want me to bring CO2 canisters to like just blast that shit when people like your instructors come out, we'll do like sparklers and fireworks. I'm like, maybe. You know me, I'm a little eccentric. I like to do things over the top, a hair. But we have we're going to have a Survivor Award. I'm very proud to do that. Follow us on Instagram. We have a Facebook group on Facebook for police only. Just answer the 3 questions. It just makes our life easy. We'll get you right in. We have over almost 82,000 members, all verified law enforcement. We have a full staff here verifying that. It's a comfortable place for you to be. And by the way, the things that we're discussing, they aren't wrong, because if it gets infiltrated, I can explain everything that goes on there because we do control it in an adult manner, and we try to make sure that we're providing good, sane legal advice. Remember, Street Cop Training is the training company that our slogan is, it's the training cops deserve. A lot of us have been shortchanged. There's some great training out there. We have partnered with a lot of people. but we kindly appreciate all your continued support as we are working on undoing what's been done and trying to resolve some of the issues that we face in law enforcement today. Zach and I continue to do these. We have full plans on continuing this program moving forward. Zach Miller's training program, Constitutional Policing, is up. There is very limited seating in his courses. It's a 2-day course. It's very practical. It's very comprehensive. And it's very, very good. Zach is one of the first instructors that when we began to audit it, actually Jay, who's our videographer, called me and said, you don't have to look at this. He's very, very, very good. He's like one of the best classes I ever sat through. And then you had been teaching for a while, but I'm glad that it's on the repertoire and to a wonderful future to Zach Miller and I together and this company. It was a big staple. I'm very, very thankful to have you a part of it. And without further ado, I have nothing else. Zach, if you have anything else?
I'm glad to be here, and I appreciate the opportunities and exposure I get from being with your group. So thank you.
Awesome. So without further ado, guys, we will see you in the next episode. Zach, take care.
All right. See you.